any notion that the United States doesn't value privacy or it's not a core value is simply a mistaken concept. This is something that's extremely important in the United States. Now, we're not arguing that our system is necessarily superior to that of the European Union, but it's important to note that our systems go about protecting privacy in different ways, and that's an extremely important point. The protections in the United States and those in the member states of the European Union, they've evolved over time based upon our circumstances, but we have in place protections that are fundamentally similar. And this finding has been made by the US-EU High-Level Contact Group, which was brought together in 2008 to talk about this issue of justice and home affairs context. And the conclusion of the EU and the US in that high-level contact group was that both the EU and the United States have significant commonalities in our approaches based on our shared values. There was extensive discussion here about the deeply rooted commitments to the protection of personal data and privacy. Sometimes it's argued, since in the European Union there are data protection supervisory authorities, and therefore that must ensure a better protection of privacy. But the United States has a different approach. And I think we would argue that our approach of checks and balances and network layered systems of oversight, interlocking provisions which protect privacy, is at least as effective, and if not more so, than the system of data protection authorities. We have different systems. Within the executive branch, the U.S. system includes chief data privacy officers in the U.S. departments, including the Department of Justice and the Department of Homeland Security, as well as inspector generals who report within their departments and to Congress, but they are fiercely independent in their investigative activities. Also in the Department of Justice, for instance, the Office of Professional Responsibility acts in these areas. Also, we have in the separation of powers, our legislative branch is extremely important in this area. They also have oversight through the Government Accountability Office, the GAO, and congressional committees. And of course, our courts play a critical role in determining whether access to data is acceptable at all through the U.S. system. The third area that I'd like to touch upon briefly has to do with the concept of, or a myth if you will, that U.S. law enforcement authorities are less protective of the privacy interests of foreign nationals or EU member state nationals than of U.S. citizens, that there's an unequal system here. Perhaps this comes from looking at the U.S. Privacy Act, which is one portion of our multi-layered system with regard to access and redress. Indeed, the U.S. Privacy Act does allow individuals to access and correct data. It does apply to U.S. citizens and lawful permanent residents. However, if you will look at the Privacy Act carefully, there are exclusions even with regard to U.S. citizens, as law enforcement records collected for criminal investigations are specifically exempted from these provisions, as you will see in a number of provisions in EU member states. One of the striking things about the U.S. system is that it has a series of protections in this context that extend to foreign nationals as well as to U.S. nationals without distinction. These include obtaining information through the powerful Freedom of Information Act, or FOIA, the Electronic Information Privacy Act, known as ECPA, the Computer Fraud and Abuse Act, the Federal Tort Claims Act, the Mandatory Victims Restitution Act. All of these redress options are available and access options are available to foreign nationals and U.S. citizens without distinction, and our courts have so ruled there.